On Friday, there was finally an arrest made in the murder of Tupac. 26 years, down to the month when this murder happened, we finally have an arrest. So Keefe D is Duane Keefe Davis. That's his real name. He goes by Keefe D. There has to be newly discovered evidence. So I don't think that the proffer, that the snitching, talking about the snitching, the interviews, his book, I don't think that helped him. But I don't think that's the only reason, because if that was the only reason, this arrest could have happened a long time ago. Because if you'll remember, 1996 is when Pac was murdered. 2009 was Keefe D's proffer agreement with the LAPD. And 2019 was Keefe's book. And he continued to do interviews on BET with DJ Vlad and various other documentaries. The police could have snatched him up right then and there if they wanted to, and they didn't. So there's got to be something new. I don't know what that new evidence is, but I really want to know. I want to know the reason for the search warrant for Keefe D's house. It was in July of 2023. So law enforcement has to have probable cause for this search warrant. They can't just wake up one day in 2023 and say, that's it, we're searching for Keefe D's wife's house today. This is a high profile case, folks. Whoever represents Keefe D will be looking through this evidence with a fine-tooth comb. There has been some new information. I guarantee you there's been some new information. And the police say they've been working on this diligently for 26 years, but something has come up. And we'll probably find out as this case progresses. But right now, my opinion is that it's absolutely more than the interviews that Keefe D did. It's more than his book. It's more than his proffer. So we're going to find out what that is, hopefully, as this case unfolds. Could there be a confidential informant? Could there be a snitch? Could it be someone who's in or out of prison? We don't know, but that certainly is a possibility. It doesn't have to be someone close to this case. It could be someone arrested for something completely unrelated, and now they find themselves in a precarious position with law enforcement and need to find a way out. And if you'll recall, that's exactly how Keefe D got hemmed up in the first place. That he was arrested for this large quantity of LSD, and he was facing up to life in prison, and he decided to snitch. As you know, Keefe D has been very open about it. He talks about it in his book. He talks about it in interviews. And so that is not normal for someone to do. Typically, when someone snitches, they don't even want someone to know that they snitch, much less what the content of that conversation was or that meeting. But we know Keefe D doesn't mind doing that. Where did the new information come from? Was it a confidential informant? It could be someone arrested by the feds for drug charges and they want a break. It could be. It could be someone who before they were not interested in cooperating or talking to the feds, and now they have suddenly decided that they want to for whatever reason. It doesn't mean they're facing a charge. It just could mean they decided to clear their conscience. We don't know. We don't know. We don't even know if this is what the new evidence is. It's just a hypothesis. So if I was Keefe D's lawyer, which of course I'm not, I'm a lawyer in South Carolina, I'd bring up some of the same defenses as many cold cases have. Like, what took y'all so long if your evidence was so strong against Keefe D? Why'd y'all wait 7 years? Remember, a trial 27 years after the incident, witnesses' memories were much better, obviously, closer to the time of the incident. Their memories have faded after 27 years. They may have cognitive problems. Maybe they have Alzheimer's. Maybe they have something that happens where they've had an accident that had a brain injury. We don't know. We'll see how this unfolds. We know some of the witnesses are dead. All 3 people that were in that Cadillac where Keefe D was, they're all deceased now for whatever reason. Or we know Orlando Anderson, who of course is the nephew of Keefe D, was killed 2 years after Pac's murder. Some witnesses can't be located after 26 years. Lord only knows where people have moved, how their lives have evolved over 26 years. We don't know. But there would also be an issue of evidence being preserved. Has evidence been destroyed? We just don't know. Some law enforcement might not even be available. Some have retired. Some have passed away. Some may not be reachable. We know that Keefe D was present at the scene of the crime. If I was his lawyer, of course, I'd be arguing, depending on what the evidence is, the new evidence, is that mere presence is not enough. That Keefe D acted in accordance with and in furtherance of the murder. And the state has the burden of proving that. Remember, it's not on the defense. Everyone who is accused in this country has the absolute protection, this cloak of innocence that they wear into court. And it's up to the state to prove, if they can, that beyond a reasonable doubt, this person committed what the state accuses them of. In this case, it's murder. If I was Keefe D's lawyer, Keefe D may claim, if this is true, that the book was for entertainment value, that the facts in the book are not 100% true. He could say that, but the proffer better be true. It better be. So that leads us into the next point, that a proffer does not give you absolute immunity. I think that that is something that, when I look at stuff in the media right now, and the perception seems to be, even prior to this case, a proffer gives you absolute immunity, and that just simply is not true. It's not realistic. You got to know what's going on with the law. When you better know what's going on, or else whatever the defendant says at a proffer cannot be used against him. He has immunity. However, if later on the police find out evidence different than what the defendant provided, those proffer statements can be used against the defendant. Looking at how a proffer works, it can fall on the defendant why they don't get absolute immunity. And that can be because the defendant lied when they went to their proffer. I don't know if that's what happened here, but that is one way to lose your immunity when you go snitching. If you lie during your proffer, that can be used against you. You can be charged with what you're talking about during that proffer later on. So we don't know if that's what happened here. It could have been. So a third party could provide information that contradicts what the defendant said during a snitch session or proffer. I'd like to see Keefe D's written proffer agreement. And yes, it is common to have those proffer agreements in writing with the feds. Keefe D did something rare here. He proffered, he snitched, and then he talked about it openly. Who does that? It is not common at all, folks. It is absolutely, it's dangerous. It can be dangerous. Most people don't do it. Most people don't even want people to know that they have done a proffer, much less do they want people to know what is contained within their proffer agreement. I think that it's just not absolute immunity. The defendant has to be completely truthful, or if there's evidence found out later on that's newly discovered that contradicts what the defendant says, then the immunity can go out. You don't have absolute immunity. So the defendant doing the proffer has a problem if he was not truthful. I'm not saying that Keefe D was not truthful. I'm just merely explaining how the proffer works. It doesn't always give someone absolute immunity for the rest of their lives. So the state murder statute in Las Vegas, Nevada, it has no statute of limitations. There's no deadline to bring charges. So statute of limitations, if you're not familiar with it, means how many years do we have from 1996 when this murder occurred to bring charges against someone? The answer in this state for this particular statute is indefinitely. There is no deadline. So you don't have to be the person who pulled the trigger to be charged with murder under the Nevada statute that Keefe D is charged with. Mere presence, though, is also not enough. There has to be some evidence alleged that Keefe D did something in furtherance of Pac's murder. He provided the weapon, he acquired the weapon, he planned the hit, that sort of thing. And I'm not saying that any of that stuff happened. I'm just explaining the statute and the allegations. So will there be a trial? Will there be a plea? It's too soon to know. We don't know what the evidence is yet. If this case is televised, it has a chance that it could be because it's a state charge. Federal cases obviously are not televised, but if this case is televised, even if it's not televised, and of course, whether it is or not, it depends on the judge to make that determination. But if it is going to be huge. It could be bigger than the OJ case. So stay tuned for more updates.